Hi, myself Dr. M. Saranya, Assistant Professor of BBA Department. Now I am going to present a topic on consideration in Indian Contract Act 1872. Section 2D of the Indian Contract Act 1872 defines consideration as follows. When at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or abstain from doing something, such act or abstinence or promise is called a consideration for the promises. In simple terms, consideration is something of value that is exchanged between the parties in a contract. It can be an act of a forbearance or a promise to do or not to do something. Consideration can move from the promisee or any third party, making it valid under Indian Act law. Next, we are going to see about the essentials of consideration. First one is it must be at the desire of the promisor. Consideration should be provided at the request of the promisor. If a person voluntarily does something without the promisor desire, it does not qualified as a valid consideration. For example, if A repairs B's house without B's request and later demands payments, A cannot claim it as consideration because it was not done at B's request. Next one is it can be provided by the promisee or any other person. Under Indian law, consideration can flow from the promisee or a third party. This is known as the doctrine of privacy of consideration. As long as the promissory request is fulfilled, uh, it doesn't matter who provides the consideration. This is in contract to English law, which requires that consideration must move from the promisee only. It can be past, present, or future. Consideration in Indian law can be past consideration, an act done before the promise is made. For example, A perform a service for B and afterward B promises to pay A for it. This is past consideration. Next one is present or executed consideration. An act done in response to a promise. For instance, A pays B for goods and B delivers them immediately. Next one is future or executory consideration. A promise made for a future act. For example, A promises to deliver goods to B and B promises to pay after delivering. Next one is this must be real and have some value. Consideration must be something of value in the eyes of the law. It doesn't need to be adequate but should be sufficient and legal. The adequacy of consideration is generally not questioned by the courts unless there is evidence of fraud or undue influence. Next one is it must be lawful. Consideration should be legal, moral, and not against public policy. For instance, promising to pay someone for committing an illegal act is not valid consideration and renders the contract void. Next, we are going to see about exemption to the consideration. Although consideration is essential for a valid contract, certain situations do not require consideration for an agreement to be enforceable. These exceptions are outlined in section 25 of the Act. First one is agreements made out of natural love and affection. If an agreement is made between close relatives out of love and affection, it is enforceable even without consideration, provided it is in writing and register. Next one is promise to compensate for voluntary services. A promise to pay for something voluntarily done in the past without request can be enforceable if it was done for the promiser's benefit. For example, if A finds B's lost item and B later promises to pay A for it, the promise is enforceable. Next one is promise to pay a time bad debt. A written and signed promise to pay a debt bear by the limitations period is enforceable without consideration. Next one is agency and guarantee agreement under section 185 and 127 respectively. A contract of agency and contract of guarantee do not require consideration to be the enforceable. Next one is doctrine of privacy of contract and consideration. While the doctrine of privacy of contract state that only parties to a contract can enforce it. The privacy of consideration rule in Indian law allows consideration to flow from a third party. This flexibility makes Indian contract law more inclusive in ensuring that valid agreements are recognized. Thank you.